Mr. Palmiter?
William Biggers on behalf of the state, Your Honor. The next matter we have for you is Christopher Palmiter. That can be found outside line 1 on Your Honor's afternoon docket. This matter is on for several items to include an arraignment, a bond hearing, and a motion to compel discovery. After speaking with defense counsel, Mr. Roseman, we agreed that the best order of operations is to handle the bond hearing first, then the motion to compel, then the arraignment. So in regards to the bond hearing, Your Honor, Madalina Cojocari, the now 12-year-old girl, has been missing since November 21st of 2022, when she was seen on camera exiting her school bus in Cornelius, North Carolina. The defendant, Christopher Palmiter, is Madalina's stepfather, who lived with Madalina, as well as Madalina's mother, the co-defendant, Diana Cojocari. According to the defendant and the co-defendant, Madalina was last seen on November 22nd, 2022, when she went to her room that evening. Neither the defendant nor the co-defendant reported Madalina missing until December 15th, 2022, when they were confronted by counselors at Bailey Middle School as to Madalina's whereabouts. At the insistence of the school counselors, the defendant and co-defendant arrived at Bailey Middle School on December 15th. However, they arrived without Madalina. School counselors immediately notified law enforcement about Madalina's disappearance. This notification occurred 25 days after the last confirmed public sighting of Madalina and 24 days after the defendant claims to have last seen her. The Cornelius Police Department responded to Bailey Middle School to conduct the initial investigation and take interviews of the school counselors and both defendants. After it was determined that Madalina could not be located and that both defendants had known of her disappearance for over 3 weeks but failed to report her missing to law enforcement, they were arrested and charged each with 1 count of failure to report the disappearance of a child to law enforcement. The arrest occurred on December 17th, 2022, and since then both defendants have remained in pretrial custody here at the Mecklenburg County Jail. The Cornelius Police Department, the State Bureau of Investigation, and the Federal Bureau of Investigation immediately began conducting a joint investigation into the disappearance of Madalina. To date, Madalina has not been found, and all 3 agencies continue their extensive search. Without question, Your Honor, this defendant's actions are a large factor in why we have not been able to locate Madalina. The delay in reporting here was critical. Madalina was 11 years old at the time. She lived with this defendant. They stayed in the same house on a daily basis, not a huge house. This is a normal 2-story house in Cornelius. In fact, the defendant told law enforcement that he works from home at least 2 days a week. And by his own admission, he had not seen her for over 3 weeks and did, according to him, nothing. He simply shrugged it off. At one point during that time span, he had a conversation with his wife, the co-defendant, who had said to him, "I don't know where she is. Do you know where she is?" He said no. And at that point, nothing further was done by either party. The idea that he could have been in his home for 3 weeks and not know that she was missing is laughable. Even if this is the only involvement in Madalina's disappearance was his conduct here, it's abhorrent, it's egregious, and it's criminal. We would ask that the bonds in this case, Your Honor, remain exactly where they are.
Anything in terms of prior record?
It is a prior record level 1, Your Honor, no convictions.
Okay, before the defendant?
Yes, ma'am, Your Honor. May it please the court, Brendan Roseman for Mr. Palmiter. So, there's a lot of backstory in this case. The state has provided us with what I will argue shortly here is limited discovery. And that first, just as the state referenced, Chris made statements to the police. He met with detectives and he voluntarily complied with interviews for an excess of 9 hours, talking with them about this situation. Chris maintains that he did not know, quote unquote, that Madalina was missing. Now that seems preposterous on its face, just like we're reasonable people, just like the state says. The girl's not home for 3 weeks, but the issue here is all in the definition of no and knowing and what that actually means, especially when you put yourself in the position of Mr. Palmiter and what he knew and didn't know and what was going on at the time. He tells the police during interviews on several occasions that he believed that Diana had taken Madalina somewhere up into the mountains. He tells detectives specifically that he believes Diana took her somewhere and that she is safe. This was not an out-of-the-blue excuse for Madalina not being reported as missing. There's several instances in discovery of where Chris talks to the police about Diana having plans to hide Madalina away. This was so pervasive that even members of Chris's family that I believe have also been interviewed by law enforcement should have been able to confirm that Diana traveled to Michigan, met with members of his family as part of this plan to hide Madalina away from unknown dangers. So there's a long-standing and involved plan to have Madalina go with Diana and hide away in another location. On November 23rd, in this series of events, Chris traveled to Michigan to recover large containers of clothing, food, incidentals, and other items. Those items are in large plastic containers. Those items are consistent with the story that Diana and Madalina had a plan to be hidden away for an extended period of time. Those items seem to be consistent with that plan. Media reports and initial reports in this case, Your Honor may recall, have Diana speaking of Chris placing the family in danger, placing her in danger. On its face, before I had any discovery in the case, my first thought was, that's a strange statement to make. Placing someone in danger because it suggests an external threat. Not that Chris was dangerous, Chris was going to hurt us. External, Chris placed us in danger. And the reason for this, and it's mentioned almost every time that the police speak with Diana and the police speak with Chris. The reason that Diana believed that Chris put them in danger is because he invested in a retirement account containing a contract for a silver-backed 401k program, and that it required him to place Diana's name in the documents as a beneficiary. And she got very, very upset about that. So much so that she believed that Chris had placed them in danger and that there was an external threat that was coming for her and Madalina because he had signed these documents. Diana was interviewed with Detective Nichols. She told the police herself that she was not afraid of Chris and was specifically asked, when she was specifically asked, she said, "No, I am more afraid of someone on the outside doing something to me or Madalina because of those papers that he signed." Diana mentions that maybe Chris took passports because he was afraid that we would leave him because of those papers. But the search warrants, unsealed search warrants from the state suggest that Diana had her passport in her car when her car was searched. Chris leaves on Thanksgiving evening. He returns Thanksgiving Eve to go to Michigan. He returns on the 26th. Diana says that the last time she saw Madalina was on November 22nd, 12 o'clock. Madalina went to bed that night before. Chris was leaving for Michigan the next day. Diana went to check on Madalina at 11:30 on 11/24 and says she was not there. So another important component of this is the relationship between Chris and Diana. Chris and Diana were married in 2017. Chris met Diana through an online relationship. The state, in its assumption of facts, assumes roles that Chris would play in Madalina's life that perhaps, and again I'll argue in a minute, additional discovery might could shed light on. What we do know is that Diana, who was the biological mother of this child, did not call the police, did not call Chris. So they asked her, when Chris left for Michigan, and he left, and he was gone from that whole Thanksgiving Day weekend, She didn't call Chris. She didn't text Chris. She didn't call the police. She did nothing. She waited. She said that she was going to wait until November 26th when Chris came home to ask him about where Madalina was. Diana didn't ask him where Madalina was because, according to her, she didn't want to cause a conflict with Chris, who at the time was 12 hours away in Michigan. So when she comes back, she says that Chris asked her the same question because he came home and asked, "Where's Madalina?" And that she repeats this question. That's something that the state just reiterated here, is that apparently, after presumably she goes missing, they come back, have a conversation with each other. And he asks, "Where's Madalina?" She says, "I don't know. Where's Madalina?" They just repeat to each other. But that's missing context because in Chris's relationship with Diana, he knows that when Diana tells him, quote unquote, "I don't know," it's because she doesn't want to talk to him. She had espoused this plan that Chris was not sufficiently acting in a speedy enough manner to hide Madalina away, and that she was going to take this upon herself. So if you think about this in context of Chris in relation to Diana, he might not know where Madalina is specifically, but he to this day still believes that Madalina is in the care of Diana with whatever person that she assigned to care for her. There's some evidence to back this up. Madalina's backpack, along with clothes, and her favorite horse dolls collection is missing from the house. It seems apparent from unsealed warrants that Diana was in communication with Octavian Sebenu somehow, which is her cousin from Florida. And I just want to reiterate for the record, because I asked the state prior to this, I don't believe that there are any other remaining sealed search warrants. Is that correct, Mr. Diaz?
Correct.
Okay. So I just want to make sure that we weren't running afoul of anything. But apparently there's information from the state that Diana had been in consult with her mother and this Octavian Sebenu in a plan to hide Madalina from Chris. During an interview with an FBI agent, the language that they used was that there was a plan that did not include him to hide Madalina away from Chris and away from everyone. And then apparently, according to reports, Madalina is seen with Mr. Sebenu on Sugar Mountain on December 3rd. Supposedly she's supposed to be in the presence of Diana, and Diana is seen traveling on Lonesome Mountain Road on December 4th. The FBI has a recording that Diana made where she is questioning Chris and accusing him of calling the police on her up in the mountains. So the warrants say that Diana sent a text message that she was in Madalina's presence on December 2nd and that she traveled on the 4th to the mountains. And then at a later point in time, there's a photograph or some type of surveillance image, I don't have it, of on the 16th of December of Madalina and Diana's cousin, Mr. Sebenu, who, from sources that I'm understanding, is a former Moldovan customs officer, that they are photographed together in the mountains. So I understand the state's argument, and I'm getting ahead of myself. But if this is true, then this essentially destroys an argument that Chris would have been involved in some type of assumed homicide or something to that effect prior to December 16th. If she's seen alive in the mountains, then that can't be the case. Chris has been in custody now for 8 months. This is a Class I. The maximum sentence he faces, by my calculation, is 6 to 17 months. Chris throughout this interaction here has been portrayed as a monster. But Diana has said on multiple times that she is not afraid of Chris and that the danger that she is speaking of is not him. He's 61 years old. He has 10 brothers and sisters, including Matt Palmiter, who's here today in support of him. He was gainfully employed with General Dynamics for about 8 years. He owns a home in Cornelius. He can only float the mortgage for so long. They've been paying the expenses off of his savings. He has no prior criminal record for a 61-year-old man, just traffic tickets. There's been no calls for domestic violence to that house that I'm aware of, no information about abuse from the police or any suspicions of abuse from the school. Nothing to suggest that Chris is a danger to the community or even took any nefarious actions in this instance. He's already surrendered his passports. He's willing to comply with electronic monitoring. Your Honor, I direct you to local bail policy, Section D. By my estimation, the suggested bond range is $0 to $25,000 secured or unsecured. He has a $200,000 secured bond. I was able to obtain a report from pretrial services, and I can approach with that in a moment if you'd like. But the suggestion for pretrial services is a written promise to appear. He scores a 1 on the activity scale. Nonviolent current offense, no other pending charges, no convictions, no failures to appear. I also spoke with pretrial. He's eligible for pretrial services. If I may have a moment, Your Honor. The state has essentially made its case that they believe that Chris is guilty of this offense of failing to report a child missing. Part of those elements of those offenses is that the person providing care or supervision of the child knowingly or wantonly fails to report the disappearance. And then there's a lesser included misdemeanor that references any person who reasonably expects the child may be in danger. So in these interviews that Chris gave to the police, he's adamant that he does not believe that Diana harmed Madalina. He believes that Diana fervently believes that Madalina is in danger from some unknown third party, apparently related to him placing money and assigning benefits to her in a 401k account, something that doesn't make any sense. So he told them on multiple occasions that Diana would not hurt this child. He believes that. He tells me he would not hurt this child. I don't think that there's any evidence here to suggest that he has done so. This issue is solely about the failure to report. That's what he's charged with. If he were charged with homicide, then we would expect the court to hear the facts under that charge and those circumstances and set a reasonable bond. So I'm asking you to hear the facts and circumstances of this case and his circumstances and to set a reasonable bond. Thank you for hearing us, Your Honor.
Oh, thank you. What does the state have to say about conserving its maximum sentence on class I prior level 1?
Yes, Your Honor, that is the state's agreement as well. He is a prior level 1 class I felon. If he were to be convicted of this charge, that would be a maximum of 8 to 19 months. But because it is a C block, that of course would have to be a suspended sentence and placed on probation. We are aware of that and obviously agree with that.
And the reason I mentioned the 6 instead of the 8 was because of the aggravating topic presumptive versus the aggravated range. I was going under the assumption of topic presumptive since we haven't been noticed of aggravating factors.
All right. I'll set his bond at $25,000 secured. If he's able to make that bond, I'll order that he be placed on the electronic monitor. I will and pretrial supervision.
Yes, ma'am, and may he be allowed to pursue employment opportunities?
It'll be on 66 first.
66, yes, ma'am.
Your Honor, we understand it's a unique circumstance, but given that there's a code amendment in this case, we would have no contact with the code amendment.
Is your good name?
They are. I don't know how to enforce it. To be completely frank, I don't know how to enforce that, but
It could be.
we have concerns, obviously.
Understood. I won't order that.
Thank you, Your Honor.
The next matter we have for Your Honor is the defense motion to compel discovery. As this is defense's motion, we just wish to be heard at the appropriate time.
All right.
Yes, ma'am. And Your Honor, I believe you may have had an opportunity to review those filings previously.
I
Is
have.
that correct? And my apologies for sending them to you late, but I sent you some other documents. I mean, essentially, I would start with 15A903, which is the discovery statute. Section A, upon motion of the defendant, the court must order, number one, the state make available to the defendant the complete files of law enforcement agencies, investigatory agencies, and prosecutors' offices involved in the investigation of crimes committed or the prosecution of the defendant. So, if I understand the state's position here, they're trying to say that he's only charged with failing to report a missing child, that came to the attention of law enforcement on December 15th, and that anything after December 15th should not be produced in discovery. I think that that's a very, very narrow reading of what a defendant's discovery rights actually are. I think I'll start with the need for potential Brady and corroborating evidence, because from what we know from the voluminous interviews that have already happened, Chris maintains that he did not actually know, and I would argue still doesn't actually know, that Madalina is missing according to what's contemplated within the statute. An example being, at least on a short-term sense, if I send my child away with their parent or mother to wherever, let's just say that Chris had sent, well, not even really sent, even without his permission, Madalina had left with Diana to go to Moldova for the summer. He has no clue where Madalina would be, none whatsoever. Her physical location, hadn't had contact with her for 24 hours, all those things. But he would have no reason to suspect that she's in danger, and he knows that she is under the care of her mother. So I think that it's a stretch to say, in that circumstance, that he would be guilty of a crime of failing to report a child. And I think that circumstances and evidence, that information that the state has surrounding that transaction would be very relevant to whether his belief is substantiated in any way, reasonable in any way, corroborated in any way. So like text messages between the parents. Oh, hey, we just landed in Moldova, we're in the capital. Those types of things would corroborate the story that I knew that she was going with her mother on a summer trip, just by way of example. And I think that those things would also clearly apply in this situation where essentially Chris is left out in the dark. He believes that she's being cared for. He knows that Diana has dual passports. I don't think that's a secret to anyone. And he wants to know where the child is, but he doesn't believe that she's been kidnapped. He doesn't believe that she's just out walking the streets somewhere. He believes that she's being cared for by her mother or whatever assignee that she's placed in his care. And so the state, I think, is making value judgments about the worthwhileness of this evidence or the usefulness of it or that type of thing, but I think that the real consideration here is relevancy. Is the evidence that the state potentially possesses here, is it relevant? Is it relevant to Brady? Is it relevant to impeachment? Is it relevant to corroboration? And so I think that financial transactions, cell phone data, text messages, which only one text message has been produced, would be highly relevant to creating a defense corroborating his statements to the police. Now, with the December 16th cutoff, I think that Your Honor is aware of the case law, states presented case law. I want to argue to you in good faith. What I'm saying is that just because, if there's information that's learned, that's relevant to things that happened before December 16th, then I believe that Mr. Palmiter would be entitled to those things to help us formulate a defense. So, all these things could be relevant: internet traffic, cell phone traffic, financial transactions, and to a large extent, and in the bigger picture, information relevant to Diana's executed apparent plan to hide this girl away corroborates his story that, no, she's not missing, she's with her mother or wherever her mother has placed her. So 15A903, I sent to Your Honor some previous news articles. There's unsealed search warrants where Palmiter mentioned that Diana Cojocari had a lot of cash with her, and he did not know where it came from. During a recorded call between Diana and her mother, they discuss the women with a bag of money withdrawing cash, and then float a theory that somehow Chris was involved in giving her away for money. But again, that wouldn't make sense if she's photographed with Diana's cousin on December 16th in the mountains. Another search warrant where Diana indicates that she's in the presence of Madalina on December 2nd. I think that communications would be highly relevant about that, because the idea being that supposedly Chris is lying or hiding or something that he hasn't communicated from November 24th to December 2nd. Well, if Diana's in Madalina's presence on December 2nd, all these things stand to corroborate his reasonable belief. I was informed, I don't have a copy of it, but I was told that Diana's mother gave an interview outside of the courthouse this afternoon, that she had indicated that she knew that Madalina was in the United States, and I believe that she had said that she was alive, but she did not know exactly where. So I think that if you place yourself in the context of where Chris's defenses lie, that this information would be highly relevant to him corroborating the only defense that he presumably may have at this point, which is his word and his belief, and whether it was reasonable and whether it's corroborated in any way. Just one moment, Your Honor. And I think that, with respect to the state's position, I know that they want to find Madalina. Chris wants to find Madalina. We all want to find Madalina. But if a protective order is necessary, we would comply with the protective order. I know the state's position on that. But I do think that Chris is entitled to build a robust defense over what he knew and didn't know, that the state has information to be relevant to that. So thank you for hearing us on that.
All right, you cited a complaint number in your motion to compel. What is that complaint number?
The complaint number, I believe, is the investigative file number. I think that it's listed.
January of 2022?
22.
That is correct, Your Honor.
Yeah, I would have transferred that number directly from the discovery. I mean, I'm not infallible, so I could have made a typo, but I
My
believe.
number would be 2022-0101-100795. This is a Cornelius case, so they do not follow the same complaint numbers as CPD.
All right, thank you. For the state?
Yes, Your Honor. As the state indicated in its motion that it filed, we are opposed to releasing certain discovery in this case. I'm certainly not going to go over the entirety of that written motion, but I do want to hit a couple of highlights for the court here today. The defendant at this time is not charged with any crimes related to where Madalina is located, and providing details about the extensive search and discovery would jeopardize an ongoing investigation and frustrate our efforts to locate her. As such, the state has not provided any documents or files obtained after the defendant's arrest that are not directly associated with the current charge. None of the State Bureau of Investigation or the Federal Bureau of Investigation files have been disclosed, as both agencies became involved only after the missing persons investigation began. As I did highlight in the written motion, there are 4 categories of things that we obviously do think are relevant. We have provided and will continue to provide as they come forward. That's essentially anything that we've gathered from Bailey Middle School regarding Madalina's absences, any statements by the teachers, their attempts to locate Madalina through the 2 defendants, any reports, statements, favors, notes, files, body-worn camera from Cornelius Police Department from when they got involved up until the point where this defendant was arrested and it turned into a missing persons case. We also believe that any of the defendant's statements, obviously, or the co-defendant's statements that were made to law enforcement, those relevant and returned over, and of course the contents of this defendant's cell phone extraction. What we would know, Your Honor, is that for this particular charge, the elements of the offense are that 1, a parent or other person providing care to or supervision of a child; 2, knowingly or wantonly; 3, failed to report the disappearance of a child to law enforcement. That statute goes on to explain that the disappearance of a child occurs when the parent or person providing supervision does not know the child's location and has not had contact with the child for 24 hours. So, defense counsel had said numerous times in his argument that his client believed that Madalina was with mom, or believed that Madalina was safe, and that is completely contrary to what statements he made. He's in this house for 3 weeks, on scene, to Cornelius, in body cam, which we have provided. He's telling law enforcement that at some point during this couple of weeks, 3 weeks, where I realized I hadn't seen her in that entire amount of time, my wife asked me, "Where's Madalina?" And I said, "I don't know." So it, again, strains any kind of concept here that there's no way that he didn't know that she was missing. And for him to say, well, maybe the kid was in a safe location for 24 hours? Okay, maybe that's a legitimate thought. 48? Getting less legitimate. But 3 weeks? 3 weeks you haven't seen your child? And you're admitting to law enforcement that both of you have not seen her, and you're both living together, and you're both there in the same house at the same time, you don't know where she is. So when it goes to that elements, which is what we need to prove, that knowing or wantonly, that's what needs to be kept in mind when defense counsel brings up all these hypotheticals or possibilities. So the state's argument really is 3 prongs. The first thing is that this is a collateral request outside the scope of discovery. The state has a significant interest in protecting these materials, and last, that case law does not require us to disclose it. So I'll briefly touch on all 3. Given that this is a collateral request, the location of Madalina is immaterial to this charge. The defendant in this matter is asking for collateral matters that is subject to an ongoing investigation which provide no possible defense to this charge. The defendant cites 2 news articles that is subject to mere conjecture as to where Madalina could be located, and assuming for a moment that either the articles are correct as to where she happens to be, that would not change the outcome of this trial. It's his knowledge that counts, the knowledge that she is not home and that she is not here for 24 hours. Where she actually is and whether or not she's safe has no impact on that charge. There is no defense associated with that. The second prong of the state's argument is that we do have a significant interest in protecting these materials, and that needs to be counterbalanced with their request. We would like to protect all materials gathered by law enforcement in their efforts to locate Madalina. Disclosing them to someone who could potentially be involved in her disappearance, or perhaps is close to someone who could potentially be involved, would catastrophically hinder this investigation. It would make potential future prosecutions in the matter difficult, and more importantly, it would jeopardize law enforcement's ability to find Madalina and bring her home. We can for a moment assume that the defendant has no additional knowledge or involvement in her disappearance. His gaining access to the investigative file could still result in these consequences. Given the extensive news coverage of this case, an innocuous conversation or disclosure by the defendant to someone else could result in the materials being made public. And if they go public, it would likely reach any party responsible for her disappearance and ultimately would cause this thing harm. Lastly, Your Honor, case law does not require disclosure. The state is not required to disclose collateral investigation to defendants until when and if charges are brought. As I highlighted in the state's motion, this is very similar to situations we see throughout criminal law. If an individual is arrested and charged with shooting into an occupied dwelling, everything associated with that incident on that day gets turned over. There is a real chance, and as often happens, that based on that arrest and that charge, law enforcement could be looking into that defendant for a multitude of other crimes. Perhaps the weapon they're recovered with is a match to other shootings that have occurred. Now, they have not arrested him for those additional charges, and for that reason, they're not going to be turning over an active file. That is standard. That's what occurs. If we were to turn that over to someone who has not been charged with the crimes, it would unfairly have an opportunity, or the defendant would unfairly have an opportunity to interfere with the investigation, attempt to influence potential witnesses, and adjust their version of events to match what law enforcement had gathered to date. So, defense counsel said a few times that this might could shed light. This might could do this might could do that. The cases that the state has handed up and the arguments that we made clearly show that North Carolina courts do not allow for a fishing expedition into every single thing that law enforcement has. We would beg the court to deny this motion outright, but at the very least we ask that if the court decline to grant any relief in this matter, that the court review these matters in camera and make a decision on her own as to what is appropriate to disclose. Granting the defense unfettered access to the missing persons investigation is going to irreparably hinder our ability to find that way. To sum it up for you, I'm happy to answer any additional questions.
All right, thank you. On these pages aren't numbered, but page 3 of the defense motion, second full paragraph, first full paragraph, you're asking for financial records from Western Union.
Yes, ma'am, Your Honor.
Whose records are they?
Well, we had been noticed from the state that they had subpoenaed financial records from Western
Then
Union.
let me hear from the state.
Yes, Your Honor. I apologize, I was remiss. We do think that is appropriate to turn over, and we will, of course, turn that over. By way of background, essentially what happened there was we made a tactical decision to get those records as quickly as possible. The company alerted us that a subpoena would be sufficient. There are some lesser-known rules of civil procedures that do apply to state subpoenas in the criminal case, particularly Rule 45b1, indicates that within 5 business days of receipt of materials produced in compliance with the subpoena ducis tecum, the party who was responsible for issuing the subpoena must serve all of the parties with notice of receipt. So, in compliance with that, that's what we did. That's why defense counsel is aware of that. It exempts us from, well, 15A2 exempts us from notifying that we have subpoenaed, only that we got documents back. And because we made a decision to move as quickly as possible, because time was of the essence, and we used this case number, and we notified this defendant, we do think that's appropriate to turn over. So that is something we agree.
All right. The second full paragraph on that page is in reference to the text message from the defendant to the co-defendant. What's the state's objection to that?
There is no objection, Your Honor. Pursuant to the motion we filed, that is a text message found within the defendant's phone. We agree that should be turned.
The next paragraph is in reference to audio recordings of the co-defendant about a plan that didn't involve this defendant. What's the state's objection to that?
Your Honor, now we're getting into the state's main point associated with this case, which is there are several things that defense counsel is asking, particularly these recordings made by the co-defendant, that could go to what happened in Madalina. Our point is that the charge associated with this, it does not matter what happened in Madalina for that purpose. It only matters that the defendant knew she was missing, which of course we've turned all that discovery over, and that they failed to report it. If she's safe, if she's harmed, if she's wherever she is, it does not matter for the purpose of that statute.
When was the recording made?
I'm not able to answer that off the top of my head, Your Honor.
Before or after December 15th?
It would have been before. These recordings were discovered on the co-defendant's phone.
All right, then the next paragraph beginning on July 17th is regarding search warrant information. You appear to have the search warrants.
Yes,
Mr. Grossman.
yes, ma'am, I do.
Is that portion of your motion withdrawn?
Well, in terms of, if I don't have any surveillance photo that is alleged to be within the search warrant, so I think that's more or less where I was going with it. And the
But
presumption,
that would have been surveillance done on December 16th?
presumably,
All right,
because I would think that perhaps, likely, there is communications between this individual and her that would corroborate my client's statements about what Diana was doing.
all right, based upon the state's representation here in open court, I'll grant the motion to compel as it relates to financial records from Western Union. Sounds like the text messages have been complied with,
Well,
and therefore moved.
if I may interrupt just briefly, Your Honor. So I checked with my investigator, and we checked the hard drives. I know the state has said that they were not opposed to releasing the contents of Mr. Palmiter's cell dump. I don't have that information. I sent him an email.
All right, well, the motion to compel is granted then with regard to his phone
Yes, ma'am.
and the data retrieved from his phone. Audio recordings about that predate December 15th. The motion to compel is granted. Relevant to what he knew or didn't know.
If I just so I'm clear, Your Honor, is that any recordings of this defendant? Not just recordings
No, of the co-defendant as well.
of the co-defendant as well? Even the ones that this defendant's not on? Okay.
If she's talking about what? Yes, yes. And then as to any material about December 16th after the court, that's tonight.
I understand that, Your Honor. Thank you. And just for clarification's sake, for electronic device communications from the, I can only assume that they would be with Mr. Palmiter, but Is your order including the co-defendant's cell phone, Cellbrite as well, or no? Prior to December, well, I think it's going to be prior to December 16th.
If there is information on her phone in communication with him, like it would be on his phone. But
right, I would
yes,
think.
that is applicable to any communications on her phone to him,
I would think.
pre-December 15th.
Understood.
But not the entirety of her phone.
Correct.
Okay.
And is it possible to tailor that for any communications on her phone relevant to a plan prior to December 15th?
No, you just get the text messages. All right, Mr. Rosen, I'll ask that, as the moving party, you draft a proposed order in a consultation with the state.
Yes, ma'am.
As to form, submit that for my signature.
Yes, ma'am, I will. Thank you, Your Honor.
And Your Honor, the state will move expeditiously moving that over. By next week. The last matter we have for you regarding the defendant matters in arraignment.
Yes, ma'am, we're ready.
Counsel, in the matter of 22 CRS 366223, one count of failure to report a child's disappearance to law enforcement. How does your client plead?
May it please the court, Your Honor, in consultation with my client, intending to plead not guilty. Request a trial by jury.
Your Honor, the state has not made a plea offer in this case. We will set this at the earliest available trial date.
It's a Carter level 1, as I recall.
That's correct, Your Honor.
All right, Mr. Palmiter, do you understand the charge against you?
Yes.
You understand what the maximum possible punishment is if you're convicted of the charge?
Yes.
And is it your intention, sir, to plead not guilty and proceed to trial?
Yes.
And our order is not guilty plea for it.
Thank you, Your Honor.
Thank you.
Is there a holding date? No, okay. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Gentlemen,